Hi, it's attorney Brandon Grable, and I want to talk to you today about a traffic stop that occurred in Houston, Texas. A driver who allegedly ignored commands and tried to enter into his home. There was an arrest and a bond set at $100. They posted Neil Letman's name, his date of birth, his booking photo, and a detailed narrative of what they say happened, and thousands of people saw it. But when I requested the body worn camera footage, the video that would show us exactly what happened, they refused. They're claiming that it's exempt from disclosure and they've asked the Texas Attorney General for permission to keep it a secret. Now, normally I'd say, well, they have their reasons. They're probably going to try to charge the guy. It's involved in, prosecution. But here's the thing, the arrest may have violated the Fourth Amendment. And so we can't really know without seeing the video. Let me explain why. So the Fourth Amendment, it protects your home. That's not controversial. It's foundational. Police generally need a warrant to enter your home to arrest you, even if they have probable cause and even if you committed a crime. But there's always been exceptions to that rule. Most of the time it's for emergencies. Is someone's life in danger? Is evidence being destroyed? Is it a dangerous felon that's escaping? And in those instances, police can immediately enter into your home without waiting for a warrant. Of course, they have the burden to prove what that emergency was. And for decades, courts have treated one type of emergency as automatic: hot pursuit. I'm sure you've heard of it, the hot pursuit doctrine. Essentially, if police are chasing a fleeing suspect, if someone ran from police and went into a house, officers could follow. So the theory was simple: you can't defeat an arrest by retreating into your home. But here's what's changed. Courts started to realize that not all flight is the same. There's a big difference between a murder suspect fleeing from a crime scene and into a home and someone who's simply driving home from a traffic stop and pulls into their driveway. So in 2021, the Supreme Court took a case to settle that question. Can police always follow a fleeing suspect into a home without a warrant? Or does it depend on the circumstances? The case was Lange v. California, and the facts are important because they sound a lot like what allegedly happened here. Arthur Lange was driving home in California. He was playing loud music and honking his horn, possibly a noise violation, a minor misdemeanor, not a felony. A highway patrol officer decided he wanted to pull Lange over, so he turned on his emergency lights and he began to follow. Lange was only about 100 feet from his home, 4 seconds of driving. So instead of stopping on the street, he drove those 100 feet to his driveway and he pulled into his garage. So the officer followed Lange into the garage, didn't have a warrant. Once inside, the officer smelled alcohol, gave Lange field sobriety tests, and then proceeded to arrest him for DUI. Lange's criminal defense attorney argued that all that evidence should be thrown out because the officer violated his Fourth Amendment rights by entering into the garage without a warrant. All the state courts said no, from his trial court, the California Appellate Court, and the California Supreme Court. Essentially, they all agreed that if someone flees, police can always follow them into the home. It doesn't matter if it's a felony or a misdemeanor. Flight is flight. So the U.S. Supreme Court took it up and they disagreed unanimously. Here's what the court held: pursuing a flight misdemeanor suspect does not always, that is, categorically, justify warrantless entry into a home. Let me break it down because it's crucial. The court said that police have to do a case by case assessment. They have to ask, is there an actual emergency? They can't just assume it. They have to have facts or information to suggest an emergency actually exists. And second, do they have time to get a warrant? So, what kind of emergencies justify immediate action? Well, the court listed several: imminent harm to others or immediate harm to others, a threat to the officer, destruction of evidence, or escape from the home. Notice what's on the list: actual dangers or actual perceived dangers that require immediate action. And notice what's not on the list: the mere fact that someone went into their home. The court said you have to look at the specific circumstances. Is this a violent crime or a noise violation? Is the person fleeing to escape or just going into the home? Is there evidence that could be destroyed or is it just a traffic matter? And critically, The court has said that even driveways and porches, what lawyers call as curtilage of the home, get the same protection as the interior of your house. You can't automatically follow someone onto their property for a minor offense. Now, there's other rules into the curtilage, so I'm not going to get into that here, but just generally understand that if it's attached to your home, there is an argument that it's a curtilage to your home and officers should get a warrant. There's always going to be counter arguments to that, though. The court gave examples of cases where police should wait to get a warrant, like the teenager with no taillights who drove 2 blocks to his parents' house, ran inside, and hid in the bathroom. The court said in a case like that, waiting for a warrant is unlikely to hinder a compelling law enforcement need. Why? You know where they're at, you know they're not leaving, and you have time to go get a warrant. So after Lange, location matters. The severity of the offense matters. Whether there's an actual emergency matters. And you can't just say, he fled away and called it a day. Now let's go back to Neil Letman's arrest. Look at what the Facebook post says. Pulled into a driveway, exited the vehicle, and tried to make his way inside his residence. Under Lange, that description immediately raises questions. First, where exactly was he when the deputy detained him? Was he still in the street, which is a public place where police can make arrests? Was he in the driveway, which might be curtilage, protected like the house itself? Was he on a porch, at the doorway, inside the doorway, in the garage? Under Lange, that matters enormously. If he made it into the curtilage, the deputy probably needed either a warrant or actual emergency to follow him. Second, what was the original traffic violation? The bond was set at only $100, which suggests something very minor. Lange tells us this matters. The more minor the offense, the harder it is to justify immediate warrantless entry. The report they provided didn't actually tell us what the initial traffic offense was that justified the stop in the first place. Third, was there an actual emergency? Did the deputy have a reason to believe Letman was armed? That he was going to destroy evidence? That there was a danger to anyone inside the house? Or was this just a guy who drove home instead of pulling over? Fourth, how much time had passed between when Letman pulled into his driveway and when he was detained? Was this a split-second decision where the deputy had to act immediately? Or was there time to assess the situation? And fifth, what exactly happened when the deputy gave those commands? How were they given? How did Letman respond? Was he being defiant and aggressive, or was he scared and confused, or just simply trying to get into his house? Every single one of these questions determines whether the arrest was constitutional under Lange. And every single one could be answered by that body worn camera footage. We're not talking about curiosity here. We need it because without it, we literally don't know whether the Fourth Amendment was violated. And that brings us to the transparency problem. The constable's office chose to publicize this. They posted Neil Letman's name, his face, his date of birth, the location, and their narrative of what happened. They told us he ignored commands and tried to make his way inside the residence. But they won't show us the video that would let us evaluate ourselves and whether that narrative is complete and whether the arrest was lawful. Now, I understand that Texas law provides exemptions, that law enforcement can withhold information that would interfere with prosecution or ongoing investigations. And the Attorney General will decide whether that applies here. And I guess I have to respect that process. But here's what doesn't make sense to me. If you're so concerned about prejudicing an investigation or a prosecution, how is the Facebook post not prejudicial? You've already told the public, including potential jurors, your version of events. You've already shown them the defendant's face by way of a mugshot, and you said he ignored police commands. If you're concerned about privacy, you've already shared his identity, his name, his birth date, his image, and the fact that he was arrested. The video couldn't invade his privacy any more than that Facebook post already did. And if you're concerned about revealing law enforcement techniques or officer safety, what techniques in a routine traffic stop aren't already publicly known? This selective transparency lets the agency control the narrative. You see the outcome. Man arrested, charged, bond set, but not the process. You're told he ignored commands, but you can't see what that looked like or whether the deputy's response was reasonable, especially under Lange. And that matters for everyone. For the public, we can't evaluate whether our constitutional rights are being respected. For Neil Letman, he can't effectively defend himself without that evidence. And frankly, for the deputy, if he did everything right, if this is a textbook example of how to handle someone who doesn't comply, the video would prove it. Body worn camera footage usually protects good officers. It's objective, it's complete, and withholding it creates suspicion even when there might be nothing to hide. The Texas Attorney General will eventually issue an opinion on whether the footage is exempt. It could take weeks, it could take months, who knows? Maybe they'll order it released and we'll be able to apply Lange properly. I guess I could also evaluate suing them under the Texas Public Information Act. I don't necessarily have to wait for the Attorney General. Let me know. What should I do? Put in the comments. Should we wait for the Attorney General to release this information, or do I make a big stink about it and sue them in court over this? But either way, we'll eventually get to see exactly where Letman was, what happened, whether there was an emergency, and we'll know whether the Fourth Amendment was violated. Maybe they'll uphold the exemption, and this will remain a one-sided story, the agency's narrative without the objective evidence to back it up. I'll follow up when I know more, but I'll leave you with this. Lange v. California was decided unanimously. Liberal judges, conservative judges, they all agreed that your home is protected, that minor offenses don't automatically justify warrantless entry, and that police have to assess the actual circumstances. Those protections only mean something if we can see whether they're being respected. And right now, in this case, we can't. Now, let me put a disclaimer here. I'm not telling anybody to flee from police. Frankly, I think that's stupid. But if police happen to follow you into your home, what I am telling you is that you have arguments to make that your Fourth Amendment was violated. Now, I promise you, more likely than not, the government is going to make a ton of arguments explaining why your Fourth Amendment wasn't violated. So it's not so clear cut. But the case law does establish that hot pursuit is no longer a category rule to just ignore the warrant requirements and go into your home. This is clearly established. Thank you for watching.